Hi guys, so going back to this this key knowledge in the study design, the previous lesson would have focused on CAV, Consumer Affairs, and in this lesson I will focus on the Victorian Civil and Administrative Tribunal, or VCAT, so in resolving civil disputes. So we're looking at the purposes of VCAT and when it is appropriate and inappropriate as well. So going back, VCAT is a non-judicial body, so it's not a court, it's not part of the separation of powers, so it doesn't have the same sort of role or powers of a court, but its role is to resolve disputes. So what is VCAT? VCAT is the Victorian Civil and Administrative Tribunal, so in exams they'll either express it in its full name or in its bracket form, and you can refer to it in its shortened form, so just call it VCAT. It was established by the Victorian Civil and Administrative Tribunal Act, so it's actually fairly new and it's actually very popular. So there's actually a handful of different VCAT locations across Melbourne. The main one is obviously in the city. So the purposes of VCAT, this is very important, so I want you to remember these things. VCAT is low cost, accessible and efficient. So less cheap, easy to access and efficient, so it's timely. So when you think of VCAT and the definition or the purpose, think of those things. I should also point out, you should also remember that it is also informal, which makes it very appealing. So their purpose is obviously to resolve disputes through alternative dispute resolution, so different methods. So the aims of VCAT is to respond promptly, so to be efficient, as well to help in a professional manner. So just because it is a tribunal, it is still something that can be taken seriously, and it also provides information. So in VCAT is split into different divisions and lists. So this will be its jurisdiction. So these are the disputes that VCAT can hear. So we've got the civil division. So if we look down here, it's to do with, say, owners corporation, just like Consumer Affairs, building and property, and other civil claims. So it could be, stuff like judge duty, almost. So dealing with things like, building permits, etc. Then we have the human rights, I should say the administrative division. So the administrative division deals with reviewing decisions made by government bodies, so like Centrelink, or for a teacher it could be the Victorian Institute of Teaching and our teaching licenses, reviewing decisions by government bodies or other authorities. So this is not an appeals process, so don't think of it as an appeals process, because VCAT does not hear appeals. So that's what I mean by review and regulation. So also planning and environment. The human rights division deals with things such as human rights, racial and religious vilification, equal opportunity, mental health, disabilities, etc. The guardianship list is to do with people who are incapacitated and cannot take care of themselves. So it could be a young person or someone who has a mental health issue and needs to be taken care of. The decisions need to be made by other people. Lastly, the residential tenancies division deals with obviously renting properties. So between a landlord and a tenant. So quickly going through these. So the types in the civil, as I've just mentioned, owners corporation, which is very similar to Consumer Affairs, domestic building works, consumer matters. The administrative decision, it could be hearing things such as land, valuations, planning, permits, licenses, state taxation, WorkSafe assessments. The human resources division, discrimination, religious and racial vilification, health and information, privacy, review decisions made by the Mental Health Review Board, etc. And then obviously residential tenancies, which is the most popular list in VCAT, deals with obviously renting. Alright, so resolving a dispute at VCAT. So obviously it's very cheap to go to VCAT. You only pay, generally a one-off fee, and it'll depend on how much, the amount of money you're seeking as well, particularly in the civil list. So obviously you've got to apply, you can pay online, pay over the phone, etc., depending on the list, and generally it's heard within a few weeks. So the first thing is generally through mediation, which I've crossed out here accidentally. So mediation is the first step. So short mediation and hearing. So looking at mediation, there'll be an independent third party, the mediator, who will help facilitate discussion between the two disputing parties. The mediator offers no suggestions and does not make a decision for the parties. They come to the decision on their own. It is not legally binding unless a terms of settlement is signed. If that doesn't work, then they can use compulsory conference. The compulsory conference will use a conciliation process. I should also point out that both the mediation and the conciliation or the compulsory conference is private. So that's one of the benefits of VCAT, and CAV is also private. If that doesn't work, then they have a final hearing. So with the conciliation, the compulsory conference and the short mediation hearing, it's very informal. The final hearing is slightly more formal. A VCAT member will make a decision. So VCAT makes a decision for the parties. And it is a legally binding decision. So it's slightly more formal, so they have to present evidence. There could be witnesses presenting things like documents, etc. To point out that one of the benefits of VCAT, because it is so informal, there generally will not need a lawyer or legal representation. You can bring one, but it is not necessary. Now, what if I'm not happy with my decision at VCAT? Well, you're kind of stuck with it. The only thing you can do is appeal to the Supreme Court on points of law or questions of law. So let's just say I've had a final decision at VCAT and I'm not happy, or particularly I want to enforce the decision because the other party is not doing what they're supposed to do or what the decision we've come to. So depending on the amount of money that I've won or in settlement has agreed to, will depend on where I enforce. So for orders of 100k or less, I'll go to the Magistrates Court. Orders over 100,000, I will go to the County Court or the Supreme Court. So if I want to appeal on points of law, I'll have to go to the Supreme Court. So appeals on point of law, question of law, so they can either be heard in the Supreme Court Court of Appeal. So if the President or Vice President was hearing your final hearing, because they are on the VCAT panel, they work actually in the Supreme Court Trial Division, so the decision has to be reviewed by the Court of Appeal, because those judges do not work with them. It would be kind of strange if one of your colleagues was reviewing one of your decisions. In any other case, you will go to the Supreme Court Trial Division. Now, like any appeal, so to have your case heard or appealed, you actually have to apply to get leave to appeal. So the court has to approve that they will review the decision made by VCAT or a lower court. So like any appeal, the appeal will either be affirmed, so they either agree, or set aside as well. So breaking up VCAT into a definition. So remember I said with VCAT, it is a dispute resolution body. It's not a complaints body like CAV, and it is not a court. So I want you to remember these things. It's timely, it's low cost, it's informal, and it is accessible. Characteristics, I'll focus on the types of dispute resolution methods. So they use mediation or short mediation and hearing, so SMAH, compulsory conference, which uses conciliation, and a final hearing. So I should also point out, remember this is private. And in the examples, I will put the lists. So the lists are residential tenancies, which is the most popular, civil, administrative, and human rights. No complex representative proceedings. It doesn't have trials. So none of this pre-trial procedures, which we'll focus on in the coming weeks. And no juries and no appeals. And no enforcement either. So those things you're going to have to go to court for. So appropriateness. When should VCAT be used? So obviously you've got to look at the jurisdiction. So the power to hear certain cases. Obviously they cannot, like I said, hear any of these issues. So no representative proceedings, any issues between employers and employees. So those doing business management, you should know it is the Fair Work Commission. Disputes between people involved in car accidents and disputes between neighbours. So if your neighbour's playing, loud noise or making a lot of noise or dust and dirt, etc., like renovating their house. I should also point out VCAT is really good because it is timely. So if you need your dispute heard within very quickly or very timely manner, it is probably the more appropriate. And of course the parties need to be willing, because you're going to use mediation compulsory conferences, and generally those will need to be between the two parties and they need to come to the agreement themselves. But obviously if it doesn't work, final hearing is used where the VCAT member will make the decision for the parties. So some strengths and weaknesses, so now almost finish. Obviously being cheaper as well. It is obviously less complex because there's no pretrial procedures, or very few, depending on if you settle your dispute just at mediation. There's no need for lawyers either. However, VCAT is actually becoming more expensive because people are choosing to have lawyers there. It is quicker than the courts. So generally 2 weeks. So if you go to the residential tenancy list, which is the busiest, generally you have to wait within 2 weeks to have your matter heard. Some lists have long delays, like the planning environments, because there's obviously a lot of paperwork involved. People like the informal atmosphere, so it helps them feel more comfortable, they're more likely to talk, and that'll also help promote the no need for legal representation. Some people prefer formality and they want to be legally represented, and this is generally in issues where one party has more power than the other. So that's coming back down to the appropriateness. But remember, VCAT can allow lawyers. There's flexibility in the process because it uses mediation and the compulsory conferences with conciliation. The parties generally do have time to talk, and there's no strict rules of evidence and procedure. I should also point out VCAT, the members have expertise. So those who are working on the residential tenancy lists know a lot about residential tenancies. So most VCAT members, so the ones deciding or overseeing the conciliation or the compulsory conference and the mediation, are actually solicitors. So they're not judges. So they've actually dealt with a lot of disputes, as a lawyer themselves. However, some will lack experience in dispute resolution. The decision is binding on parties. Okay, remember this: the final hearing is binding because the decision is made by the VCAT member, and terms of settlement can be signed with mediation and compulsory conference. However, you must go to court to enforce any VCAT decision. That's the same with consumer affairs. So with VCAT, make sure you know its purpose. So remember those 4 terms. Obviously dealing with resolving disputes. So timely, so quick, efficient, low cost, informal and accessible. So it's easy to access for people. Appropriateness is to do with, can that case be heard there? So going back to, what is the jurisdiction? Is it fall within VCAT's jurisdiction? Are the parties willing to come together and negotiate and talk through by using mediation and compulsory conference? Of course, there is final hearings as well. Doing with the timeliness, do you need a decision that's made very quickly as well? Thinking about, the power imbalance, maybe you might end up having to go to court. Do you want a jury present? Do you want formality? So those are the questions you need to ask. And going back to, consumer affairs as well, is there a more appropriate way or that the dispute can be resolved? So if you guys have any questions, feel free to email me. Thank you.